Ocala's information station, 1370 WOCA.
Ocala.
All right, 25 minutes before 11 o'clock. If you've been waiting to hear that music so that you could call in and ask a question about some legal situation that you or somebody you know might be in, this is the moment. And if you want to know if this is a live show, if your calendar says that today is Wednesday, January 22nd, 2014, then you are listening to a live show, and you are invited to call in and speak to John Fuller. He is your host on this show called Legally Yours. He, of course, is an attorney at the law firm of Fuller & Fuller, and John Fuller is here to answer your questions right now at 622-9622, 622-WOCA. That is the WOCA Climate Control Source Hotline. Good morning, John.
Good morning, Larry. It's good to be here with you, and good morning to those folks who are listening to us. It's always a pleasure to have you call in. We have, I think, just some really talented people in our audience who call in frequently, and they are astute. They are aware of the legal system and its impact that it has on our lives and our institutions. So it makes it a very pleasant thing. So if you have a legal question or a legal issue that we could discuss in general terms, call us. Obviously, if it's a specific case, we'd be happy to see you in our office, either here in Ocala or in the villages. So one of the things we talked about a little bit last week were people who get injured as a result of the negligence of some other person, right, whether that be in an automobile accident or whether it's a fall down case. So I want to talk about some things to do in that situation. But I understand we have a call, so let's go to the call.
Yes, sir. You do have a phone call. Good morning. You're on the air with John Fuller.
Good morning, Mr. Fuller.
Good morning.
It's good to listen to you.
Well, thank you, sir.
I have a quick question. I won't take much of your time. Two-part question. Who convenes a grand jury, and who determines the number of people that will sit on a particular grand jury within this area? I'll hang up and listen to you off the air. Thank you very much.
Well, those are great questions, and let me see. I may not be able to give you the specific answer to the question. The statute governing the grand jury provides that a grand jury can be impaneled by the state attorney calling for the grand jury. The grand jury is made up of citizens who have not been convicted of felons, who are over 21, who are licensed drivers in this community, geographic area, this judicial circuit. And the statute provides that the grand jury shall serve for an appointed time. And I apologize, I cannot recall specifically how many months a grand jury is impaneled. That doesn't mean that they do anything. That just means that they have been appointed, they're on the grand jury, and if a case comes up during that period of time that the prosecutor thinks should be investigated by the grand jury, he may present that case to the grand jury. And if a grand jury's session has expired, then the court would appoint a new grand jury by pulling names. The grand jury, and I'm going to go out on a limb here, this is kind of a guess because I haven't looked at it in many years. I think it is a number of citizens between 18 citizens and 24 citizens. But that as soon as I say that, somebody's probably going to go to the statute, Google it, right, and come back and say, John, you're wrong, because this is one of those things that you don't deal with every day. Lawyers, defense lawyers, do not get to present evidence to the grand jury for their client.
Really?
The only evidence that a grand jury hears is what the prosecuting attorney wants them to hear. There is a well-recognized cliche that has some substance to it, in my opinion, that a prosecutor could get a grand jury to indict a ham sandwich if he wanted to. because he or she only presents the evidence that they want the grand jury to hear. The witnesses that testify before the grand jury are not subject to cross-examination. The defense lawyer has no right to present evidence if you're representing an individual who's being investigated by the grand jury. So it's totally different than the trial. And it is an interesting, we could spend a whole program talking about it, and I assure you if it was of interest, we could do it, and I would get all the right answers and look it up. But the grand jury, after hearing the evidence that is presented by the prosecutor, it elects a foreman, and then they review this evidence. And then they have three options. They can return what is called a true bill of indictment. That means they say that we believe that an offense has been committed and we indict the citizen who is being investigated and he is charged with a specific criminal offense. They can return a no true bill, is what it's called, which means they've considered the evidence that is presented to them, and they do not think that the evidence supports a charge of a criminal offense.
Sounds like that rarely happens.
Or they could do it's usually, I guess, majority grand juries return indictments, but sometimes they don't. Sometimes they are cases in the community that have very, very high emotionalism and political repercussions, and the case can be put to a grand jury with the theory that it will get a more balanced view than just a prosecutor making the decision on his own. Because the influence of the prosecutor is so heavily weighted, I don't think that happens in actuality. The third thing a grand jury could do would be to refuse to indict anyone or with a crime, but to issue a report. And that report could be exceedingly critical and scathing. And of course, the report is authored by the prosecuting attorney and adopted by the grand jury and signed, and then the grand jury sends out a report. So that's the way a grand jury works. They don't hear the trial. They don't determine guilt or innocence. And the defense has, the accused or the subject of the investigation has very little protection. If you are subpoenaed before a grand jury, you do get certain types of immunity so that anything that you say to the grand jury cannot be used against you in a court of law. However, independent evidence that could otherwise be developed, notwithstanding what you say, can be used against you. That's called use immunity, and it's conferred upon you by the statute. The first thing they usually do is send you a letter and invite you to appear before the grand jury, and if you voluntarily go and appear before the grand jury without a subpoena, you have no use immunity, and anything you say in the grand jury room can and will be used against you. So everyone, in my view, should consult with a lawyer about the advisability of whether or not to testify. You always have your rights when you are before a grand jury, unless you've been subpoenaed and been given immunity. You always have the right to respectfully refuse to answer any questions on the grounds of your Fifth Amendment protections against having to give evidence that may inculpate you in a criminal case.
The phone line is open if you have a question for John. The number again is 622-9622. Again, you're listening to a live broadcast on Wednesday, January 22nd, 2014. I tell you the date so you know if it's live or not.
Getting back to things that may affect more of us, fortunately, most of us don't find ourselves called before a grand jury in any capacity, but we oftentimes experience or have family or friends who are injured. And we talked about this briefly last week. If you are in an accident, Whether it's a fall down case because someone negligently maintained their premises or failed to maintain their premises in a safe manner, or if it's an automobile accident. In this day and age, when almost everyone has a cell phone, if you are physically able, certainly your first priority is to get emergency medical treatment if you're severely injured. But if someone's with you or you're able, take pictures. Take pictures of the vehicle. Take pictures of the scene. Take pictures of skid marks. Take pictures of your injury. Take pictures of the floor if you tripped and fell or slipped and fell, that sort of thing. That's the best evidence. And we have unique technology now that allows everyone to basically do that, which we didn't have even a few years ago.
Yeah.
So that's important. The other thing that's very important is to promptly seek good medical attention. And when you do that, be a good historian. Don't try to exaggerate your symptoms, but don't try to be a tough guy and minimize your symptoms. Just tell it like it is and be thorough and explain the mechanics of the injury and what those injuries are. And then the third thing is do what the healthcare professional tells you to do. If he says come back in a week, don't be a no-show because they'll argue this wasn't important, you really weren't hurt, that sort of thing. I'm reminded, I mentioned last week, my father-in-law who listens frequently, Bob in Naples, want to wish you well because he had an accident that resulted in a fracture that's got him laid up for a little bit. And when you see something like that, it makes you appreciate good health. Recovering from fractures and broken bones is a slow process. And do the things that the doctor tells you to do. I see people who suffer severe fractures and they don't stop smoking. And smoking is one of the biggest interferes significantly in the healing process. Every surgeon I know cautions their patients, don't smoke, especially in orthopedic type cases, because it cuts down your circulation, it delays the healing time. And, I have a case right now that I'm going to be working on Friday. 21-year-old severe injury to his leg, and he is struggling with non-union. They put it all back together, and they nailed it all together, but the bone's not growing. And so, you want to be sure that if you are in an accident that you take good care of yourself. If you think you're hurt because of the fault of someone else, then of course you should consult with a lawyer because there are a lot of things that need to be done in accident cases that need to be done early on in the case because evidence tends to move. Witnesses who may have seen the accident have moved away or their memories fade. Physical evidence, the car gets towed away to salvage and you don't get pictures of the impact. The skid marks, if there are any, the scuff marks, all of those things need to be investigated quickly. So if you're injured in an automobile accident, you have a significant injury, and certainly if you care to talk to us, we'd be happy to talk with you at 352-547-4292. But certainly be your own best self-help in gathering this information and getting proper treatment.
There was a story, you probably saw it, about some of the first responders from 9/11/01 in New York who were receiving disability compensation, and now there's a case against them because there have been photographs surfacing of them out fishing. There's one picture of a first responder. I don't know if he was a firefighter or not, but he's holding a giant sailfish, and apparently he's been receiving disability compensation for a while. And the argument is, how disabled is he if he can go out catching sailfish? And my question is it possible to take somebody who legitimately is due compensation and skew their case by, couldn't one photograph be taken out of context?
Well, absolutely. And that's why you have the burden of proof on one side or the other. But once you recover benefits, and of course my wife Janet Fuller, who specializes and handles exclusively Social Security disability, could better speak to that in Social Security. But just in an automobile case or a trip and fall case where your injuries are documented and you say, I can't lift or bend or stoop because it causes me severe pain. And then the insurance company, they love to do this. They hire somebody to go follow you around, kind of like peeping into keyhole. They hide behind the tinted windows, and they have little sneaky Pete cameras in their purse, and they follow you around. And if they see you pick up a bag of groceries or see you carry in your grandchild or something like that, then they will come to court and they will bring that videotape and they will say, ha ha, gotcha, you lying. You said that you were injured and couldn't do this. And the thing that I respond to that, and I think it's a valid response, is, Mr. Defense Lawyer, would you please show to the ladies and gentlemen of the jury, where is the pain meter on that video camera that you saw? Yes, my client bent over and picked up his grandchild who had fallen off his bicycle. But you didn't see that after he picked up that child, he had to go into his house. He had to take 2 narcotic pain relievers and lay down on an ice pack because he was in such excruciating pain from the herniated disc that was aggravated by that thing. And where is the pain meter on that apparatus that you have? Because a picture may be worth 1,000 words, but it's not worth every word, and they can't measure pain. You can't see pain, and you're not going to have or narcotic medication prescribed for you in general by medical professionals if you don't have severe pain. And there are enough objective findings with electromyograms, nerve conduction studies, MRI tests, CT scans, X-rays that can look at the underlying anatomical structure and give evidence as to whether or not there are damages there sufficient of which to cause pain. So yes, is it better not to aggravate things? Yes, that's true. But some people are in this intolerable position that they're hurt. They're hurt through no fault of their own. They're doing the best they can, and if they don't get up and go to their job, they're not going to have money to pay their electric bill, and the electricity's going to be turned off. So they get up, they take 2 pain pills, they go do the best they can, they come home, they have no life, they lay down, they spend the whole weekend flat on their back trying to gather their strength and their wits to cope with the pain. And so they bring in all these pictures that show somebody doing something that they contend if you were hurt you can't do. Now there's valid things. Are there people who malinger and take advantage of the system? Absolutely, and that should not happen. And if you have someone who is repeatedly photographed dancing and partying and that sort of thing, but photographs can be very misleading. I had a client who had his leg crushed, had 7 major operations on it, and he went to his roommate's birthday party, and several of the young ladies at the party with his crutches had him walk out on the dance floor. Someone took his crutches, and 2 pretty young girls had his arm around him, and he was smiling, standing on the dance floor.
Don't blame him,
And someone put that on Facebook, and that's another thing to be very, very cautious about. Social media can be a killer because things can be put on that are so taken out of context, and that's out there in the public view in a lot of cases, and someone sees that, and then they try to distort it. This young man couldn't walk 20 feet across the dance floor without crutches, cane, walker, wheelchair. But once they got him out there and they got him up, they took his picture, he was smiling, and the implication was this guy's out there dancing. Now, if you are out there dancing and they get a videotape of you dancing, then you probably are going to have a hard time explaining how it hurt you so bad. But again, each case is dependent upon the facts of that particular case.
And listening to you answer my question was like watching a skilled athlete. I mean, you are obviously you went into defense attorney mode, and you could hear the clever way you think coming out. And I love when you do that. You do that almost every show, at least one time.
You're very gracious in your comments, and I appreciate that. The important thing, the clients that we have, the cases that we have, I feel very strongly about them,
right.
and it is my job. It was once said that lawyers are supposed to use language to paint word pictures so that jurors can collectively understand the facts of the case and apply their collective judgment in a manner that is greater than the individual judgment of any individual. And I went to a seminar 40 years ago with a fine trial lawyer, and he said one of the essential tools that a lawyer must have is to be able to walk people through a cathedral of language and be able to and my gosh, you're in radio, so you're a wordsmith. You have to do this day in, day out. It is something that I think is an important tool to try to do it. I heard another friend of mine who's a fine trial lawyer. He says, I go to the courtroom and I paint word pictures. Some days I paint better than others, but I always try to paint the very best I can.
And it looks like we have another phone call coming in. Good morning. You're on the air with John Fuller.
Hey, good morning, Larry, and good morning, John.
Good morning. How are you, sir?
I'm doing great. I just wanted to say, you take John's answering of Larry's question concerning them showing the person supposedly injured that's out fishing or whatever the case is. What I would just suggest to the listeners that the corporate-controlled media indirectly or directly works with the insurance companies to show exploitation for the sense of profit. And what I also would bring to any listener's attention is when an individual human being that just gets up and goes to work every day needs help, he needs a lawyer in representation when it comes to legal matters, because he or she oftentimes is going up against an insurance company which has teams of lawyers and a lot of corporate influence. So that's why the Lawyers Guild of the United States fights and supports one particular political party in general, because they make a living off of defending the individual rights, which is what Abraham Lincoln did, going up against the Mississippi River Delta companies that thought they owned the Mississippi River back in the day, and he fought for farmers. So, if we really like our individual rights, we need to be able to defend them, and they are defended by the likes of the gentleman in your studio right now, Larry, and John, the lawyer, and like your father did as a policeman. So if we just hand it all over to Wall Street, we're going to end up with a very antiseptic, corporate-driven society called fascism. But I thank John for what he does. He's an asset to folks that are bright enough to ask for his help.
Well, thank you so much for taking the time to call. Thank you for your insight, and certainly thank you for your kind and gracious comments. I appreciate that.
Once again, the half hour went very quickly. I was going to squeeze in one. Is it possible to do it?
I'll try to talk fast.
All right.
Sometimes I think slow, but I'll try to talk fast.
There was a story this morning about a young 26, 28-year-old woman who, when she was 12, was sexually abused by a female teacher. The video shows her calling the former teacher, now some 12 or 14 years later, and the teacher is now an assistant principal. And so the girl is... she's upset that this woman who had abused her sexually when she was a child was now in a high position at a school. So she calls her and videotapes herself with the speakerphone on, and you can hear the woman acknowledging that she was in fact guilty of abusing the girl when she was 12. The girl also narrates her own video, and she says the statute of limitations is over, so they can't do anything to her. So while that might be true, giving it the benefit of the doubt, could the woman who now has resigned from her job as assistant principal, the one who was, who unwittingly admitted to the entire world her guilt, could she actually sue the girl for exposing her that way?
Well, under Florida law, you do have expectations of privacy, and we do have wiretap laws, and you have to have consent to tape someone. So now if you put a recording on a voicemail or answering machine, there's no expectation of privacy there. If you are a law enforcement officer and the way it should have been handled, if in fact there was any reason to do it from a criminal law standpoint without a statute of limitations question, they should have, the law enforcement should have gone and gotten a warrant if they had probable cause to do a wiretap, and then have the individual who was the alleged victim call that person after you had a lawful wiretap on it. But you can't just record conversations that you have on the telephone with third parties without their knowledge or consent.
Wow.
But now, from a practical matter, let's be real here. We've got all these technical rules and regulations, but human beings are pretty smart people and have a lot of common sense, and I've always admired that in every juror I've ever had. I don't think that there would be any real sympathetic jury that would provide much in the way of damages for someone for that transgression when the person has not been prosecuted because of the expiration of the statute of limitations.
Sorry, I brought something up so late, but I'm glad you said that, because so legally she would have something, but in reality... you
have to measure things against what I call just plain good common sense. When a juror takes an oath to serve on a jury, he or she doesn't take an oath to abandon their common sense at the jury door. They bring their collective life experiences into the jury room, and believe me, that's an asset.
And what an asset you are. I think, I know you think I don't know, you just impress me every single time, especially when you get into that defense attorney mode, then it comes out. And I like bringing you there, by the way. It's kind of like my little game. John, what is your phone number? How do we get a hold of you?
Yes, we would be happy to talk with you about if you're hurt in an accident or have any type of commercial or business case. Our office number is 352-547-4292. Our toll-free number is 855-534-2565. We have offices in the Villages and Ocala, and if you have a problem and we can help you, we'll be happy to talk with you.
And if you would like to share what you just heard with anybody you know, or listen to it again, remember, we do record these as videos. You can actually watch John if you haven't seen them already. Go to the WOCA YouTube channel, and you can look through there, scroll through there, and see almost all of the broadcasts that we do live here in the studio on this show, as well as the Voice of Ocala in the afternoon. Thank you, John.
Thank you, Larry. Good show. Enjoyed it as always. Thanks to our listeners.
All right, we'll be right back.
Ocala's